Good morning, everyone. Thank you for joining this program put on by the Office of Planning and Development, Bureau of the Business and Economic Affairs of the state of New Hampshire. I am Legal Services Counsel for the New Hampshire Municipal Association, and all of you who are joining us today are all members of NHMA. And since you're a member, you have the ability to get assistance from the NHMA Legal Advisory Service. I lead that along with my colleague, Jonathan Cowell. So if you have questions about a pending application or a planning board issue, you can contact us at legalinquiries@nhmunicipal.org, or you can call us at 224-7447. We've been a little busy lately, so it's a little bit harder for us to get back to you in the 48-hour time frame we try to, but sometimes you get lucky and you can talk to us directly on your first phone call through. One thing I would just mention for those who send me emails and have inquiries on, say, a planning board application, it's really important sometimes you please give me a telephone number I can call you back at, because there are many times when I see your questions and I really need to get follow-up clarification of the issues you're having. So please try to provide me a telephone number where I can call you back. So that's the NHMA Legal Advisory Service, and it's a little bit about me. This Planning Board Basics presentation, it's really a two-part presentation, Planning Board Basics, that we're doing from 9:10 to 10:30, and then I'm going to be addressing a separate set of concepts and issues for planning board members under roles and responsibilities. But they all kind of blend together, and they're all part of the basic package of what I consider to be the essential elements of knowledge of the law, of the learning you have may pick up over time to become an effective member of a planning board. But the starting point in many of my presentations, and I think it's essential for a planning board member, is to know the right to know law and how the right to know operates, especially with regards to public meetings. I sometimes use a comparison to the situation, and I'm going to try it again here right now. You may remember from Star Wars where Luke Skywalker asked Obi-Wan Kenobi, "What is the Force?" And he says, the Force is something that surrounds us, connects us, binds us together, and is in all things related to the operation of the universe. And you know what? That's what the right to know law is. It binds everything together in the management of a local government, and it defines in many ways how we conduct public business. So I always feel it's important to begin with the right to know law and some of the elements that are particularly important for a planning board member. The starting point, and this is how the right to know law operates, is that the planning board is a public body. And why is that important? Because if you're defined as a public body, then and you meet as a quorum of the public body, those meetings have to comply with the essential three requirements for under the right to know law. In order to have a proper public meeting of a quorum of the planning board, you have to give a minimum 24-hour notice to the public in two public places, one of which can be on your website. You have to keep minutes of that meeting, and you have to permit the public to have access to that meeting. So it's notice, public access, and minutes. Those are the basic elements of how you define the availability for the public to have full knowledge of the workings and the decisions and the discussions by the planning board. And this has come up in the past, maybe less so now, but when the planning board has a work session, maybe you don't have a pending application, a work session where you're just discussing the business of the planning board, or perhaps you're discussing, I remember a couple of years ago, the planning board I represented had an engineer come in one time to give a presentation, a short workshop on what's the difference between a retention basin and a detention basin. And again, that's a training program, but it's also part of the planning board's jurisdiction to manage drainage as part of a subdivision or site plan. And so certainly that was something that the public had a right to know about, and it was a public meeting. So you had to give notice. You had to keep minutes of that meeting, and the public had the right to attend. One other thing which we've had a lot of questions about this recently in the Legal Advisory Service. Does the public have the right to record at your public meetings? And guess what? They do. They can record anything that takes place in your public meetings. They don't need your permission, so they can take out their cell phone or other audio or video recording device and record anything that takes place in that meeting. And by the way, I know that some people think, well, what if I'm just in the audience and I want to speak? Don't I have a right to privacy to speak without being recorded? And the answer is no. We do have a wiretap statute that prevents the unauthorized recording of people, their video, or mainly it's directed at the oral statements by someone. That cannot take place where a person has an expectation of privacy. But if you're at a public meeting, you don't have an expectation of privacy. So anyone in that public meeting can be recorded, certainly the members of the public body. The other thing it's important to understand in terms of notice requirements, clearly, as those of you who are familiar with the planning board's operation, in many ways, the planning board has a separate and independent set of notice standards to give notice of, say, zoning amendment hearings or meetings to consider accepted applications or meetings to have public hearings, and there's 10-day notice requirements. Sometimes there's separate notice required to be sent to abutters and other affected parties. So clearly, there are other statutes that govern how much notice you have to give, but I'm talking about under the right to know law, which is the minimum amount, which is 24-hour notice, excluding Sundays and holidays. You don't include Sundays and holidays in the 24-hour notice period, and posted in 2 public places. Minutes have to be kept, as I've indicated. Every time you have a public meeting, you have to keep minutes. And there are certain minimum requirements. Yes, go ahead.
Steve, I wanted to kind of jump in quickly here. We did have a question in the chat. The question is a recording considered legal record, or do only the approved minutes count? She asks because can there be a disparity between the two?
Well, I guess I put it this way. What counts legally is that the public body, the planning board, has to have minutes of its meetings, which I'm going to discuss what has to be in those minutes. But many planning boards are using supplemental means of recording their meetings these days, and they may be recorded on Zoom, they may be on a tape recorder. I've even had situations where a planning board was the subject of a contentious matter where the applicant brought in a transcriptionist, a stenographer. Those supplemental pieces of information might aid the secretary of the planning board to put the minutes together, but they don't define what's required. What's required is the minutes, which are kept and made available within 5 business days. So I would not recommend that a planning board rely upon a Zoom recording as the record of their meeting. They still have to have minutes, but these could be supplemental there too. Now, in the Superior Court, if I've had a litigation, which I've done before on quite a few occasions, many times someone will argue the minutes insufficiently captured what took place at a particular discussion, and they will come in with a transcript or a recording which has been turned into a transcript and argue to a Superior Court judge, we should be allowed to supplement the minutes because they're more descriptive in this recording or this transcription of the meeting that was done by a stenographer. That can happen, but still ultimately the duty of the planning board under the right to know law is to create minutes. So your minutes have to be made, kept and made within 5 business days, and there's certainly a very minimal amount necessary. You have to have the names of the members present, the people participating, which isn't everyone in the room, it's people who speak. And by the way, when people speak as either an applicant or an abutter or just a concerned citizen, please be sure to have the person who's taking the minutes get that person's name and address. And the chair should be sure to, remind people you got to stand up, speak up, state your name, state your address, and eventually, when you're done in a reasonable period of time, please sit down and be quiet.
Okay, great.
And then again, the other parts of the minutes also have to contain the summary of the subject matter that was being discussed, decisions made, and then you also have to provide the names of persons making and seconding any motions. So I would just tell you that certainly it's the expectation is you're not going to be able to have your minutes approved within 5 business days. So you really have to have some reliance upon a person who's going to prepare draft minutes and make those draft minutes available within 5 business days. And at the next meeting of the planning board, you would approve those minutes. There's 2 really common ways you would find that a planning board would need to consult with legal counsel or receive the advice of legal counsel. The one way you might do it is to have counsel in the room. And so that's under the right to know law considered a non-meeting. It is a meeting outside the boundaries of the right to know law because the planning board has a right to have a confidential communication relationship with their attorney. So you can meet with your lawyer at the lawyer's office. You don't have to post a notice of that meeting because that's allowed to occur. Or you can have a non-meeting that's not on the agenda, excluding the public either before or during a planning board meeting. So that's considered a non-meeting. But you also have the ability to go into non-public session. So to go into non-public session, you have to be in a public session, and then you convene a non-public session excluding the public because you're going to review legal advice received from your lawyer, and that legal advice could either be in writing or the lawyer may have picked up the phone and talked to the planning board chair and gave the member or the chair advice, and that can be discussed in non-public session.
Okay, we got another quick jump in here, Steve.
Sure.
Question is, I feel my town's right to know rules actually stifles discussion and progress. It states, other than setting an agenda, arranging a meeting, and forwarding draft documents for review prior to a meeting, communication between members about business is not allowed to take place other than at a noticed public meeting. They have interpreted this to mean that no member may speak to another for any board-related purpose. Is this too stringent?
Well, I don't want to call into question the cautious approach that your town has taken with regards to ensuring compliance with the right to know law. But it isn't true that one member of the planning board cannot pick up the phone and talk to another member of a planning board about something that took place at a meeting the day before or about to take place. But the danger of doing that is if that turns into a series of sequential communications between planning board member A talking to planning board member B, and then member B says, guess what number A just told me? And then B talks to C, and I just heard the following from A and B. And that creates a circumstance which definitely would violate the right to know law. I'm not prepared to say that the town's rules here are out of bounds, because the idea of ensuring planning board members only discuss substantive business at planning board meetings, that's the correct approach. And I don't think that stifles anything. That just makes sure these essential discussions are taking place where the public can hear what's going on. The public can understand how you're making decisions and what's the information that forms the foundation for your decisions.
Great, thank you. One more follow-up for clarification. Someone wants to know, did you say those who offered and seconded motions need to be in the minutes or not?
The person who makes a motion and the person who seconds the motion, their names must be recorded in the minutes. That's required under the right to know law.
Okay. Quickly, another one here about minutes.
Sure.
Do you have to put draft minutes on the website or just available at the office?
Okay, so the law now provides that if a public body chooses, and this is the town, to post meeting minutes on your website, which, by the way, you're not required to do, what this law says is if you do post minutes on your website, you're only required to post approved minutes. You're not required to post draft minutes. So only approved minutes are required to be posted on your website if you're posting minutes on your website. The law also provides that if you don't post minutes on your website, you do have to post a notice on your website stating where at town hall someone can go look at those minutes. So
thank you.
So I've already kind of dealt with this communications outside a meeting, but I think the key thing I want to emphasize is emails and the danger of emails. So I would just completely discourage any emails being sent to a quorum of a public body where all the email addresses are in the to or CC section of the email, which has the potential for someone who is a member of the public body, the planning board, hitting reply all, and now you've started a potentially improper communication outside of meeting. So email strings of that type should be avoided. If I need to send an email to a quorum of the public body, if I'm the chair, you're going to use the blind CC method. And that is, you're going to put the email addresses of those receiving the email in the BCC section of the email. And then when I send it out and I receive it as a member of the planning board, I cannot hit reply all. The reply will only go back to the one sender, which preferably would be someone from town hall or a staff person or the chair. And that minimizes the potential for improper email string communications amongst the quorum of the planning board.
Okay, quick follow-up, Steve. Does all of this apply to a commission, such as a broadband commission? Maybe the references for minute keeping and things like that.
So I would just say, generally speaking, these obligations under the right to know law attach to any entity which is a public body. So a public body is typically a board or commission or committee created by statute, or it could be an advisory committee, board, or commission created by vote of another public body. I know that RSA chapter 53-G, I hope I got that right. You'll correct me if I got it wrong, Stephanie. There's a new broadband mechanism. It's a mechanism for towns to band together to create broadband districts. And they have this committee that is made up of representatives from the various towns. That organization is clearly a public body and would have to comply with the right to know law.
Okay, one quick follow-up. Does public body right to know law include any municipal boards, commissions, or would it also apply to a homeowners association type board?
Okay, so a homeowners association is not a public body. It is an organization of private homeowners who have been required to join to manage, say, some piece of property where they all have homes. That's not a public body. It has to be a public entity. So a homeowners association would, by definition, not be a public body. It's a private entity, and the right to know law does not apply to homeowners associations. It doesn't apply to nonprofit organizations. Although in certain instances, like the New Hampshire Municipal Association, although we are a nonprofit organization, we're also subject to the right to know law. But we are the exception, not the rule. Most nonprofits, most local organizations, like the Bow Garden Club, they're not public bodies, and they're not required to comply with the right to know law.
I think we have a question from a caller. If we can reach
yes. So caller with the last 4 digits of your phone number 3118. I'm going to allow you to unmute yourself and ask your question. And to unmute yourself is *6, by the way. Oh, they've lowered their hand. I'm assuming maybe their question was answered already, so.
Okay, wait.
Yeah.
Okay.
We'll move on.
Okay.
They can always raise their hand again.
Thank you,
Thank
Katie.
you.
Yep.
One quick little follow-up with that, Steve. Another question. Can you attach mail or information to all members prior to a meeting so they have it via email? I think maybe that was in relation to the BCC or something for clarification there.
Absolutely. I'm a member of my ZBA in my town, and staff sends out the packet to me using the blind CC method. I get an email and I can't hit reply all, and they either send me a link or the actual documents, which is the packet, the application that we're going to have with the ZBA, backup information. That's perfectly permissible, very desirable for planning board members to get a packet of the documents they have to deal with or address or consider or take into account at an upcoming public meeting, because I just would emphasize, you cannot understand and absorb a 10-page detailed civil engineering report when you're sitting at a meeting for the planning board. You really need to have the opportunity to receive those materials beforehand so you can give it due consideration, because it's not possible to do that at public meetings, especially when it's dragging on to 10:30 at night.
Yeah, the planning board members have to do their homework, right, Steve?
Homework is important.
Yeah.
And yes, I think it's a very good idea. Finally, on the right to know.
Glenn
Go ahead.
Koppelman has saved me. He bailed me out because he said, yes, RSA 53G is the communication district statute. So thank you, Glenn.
I got the number right. Thank you, Glenn. So for sidewalks, which I really think are really an important element of doing your job as a member of a land use board. I always did them when I was a member of the planning board in my town for 10 years. I didn't always was in charge of it. We just did it as a regular practice. And I don't think there was a subdivision or a site plan we didn't do a site walk on. And we're still doing it now with my zoning board of adjustment. There's just no better way to really understand what someone's proposing, because the two-dimensional plans just don't speak to you in the way that you can get the information that's really important to a decision you have to make by standing right there at the property that's under consideration. But site walks are public meetings, and they should be treated as public meetings. And I think the way we do it at my ZBA is we have all of our ZBA meetings are on the third Tuesday of every month. And so if we're having an upcoming application, I will get a notice, and it's the same notice sent to all the abutters that there's going to be a site visit for the property, typically on the Saturday before. But now that the weather's warmer, now we're starting to have the site visits at 6:30 in the evening or at 6, and then we have our public hearing at 7:30. So it's really beneficial to really know what's going on. But it is a public meeting, so someone has to be there to keep rough idea of the people who are there, things that were said, and we don't make decisions at site walks. So those minutes have to be kept. The property owner has to consent to allow the board members to go to the property, and they have to preferably, I really think that's kind of, you have to do it. You have to also get the consent for abutters to be able to walk on the property of the applicant. It is possible that individual members can visit sites, that sometimes some towns have that, process where they notify the applicant that individual board members might drive by or walk to the property. But I think I prefer to see, if you can do it, as site visits where all members of the board and the public can attend at the same time.
Okay, Steve, jumping in quickly just to back up for a second. And question is, beyond minimum minutes requirements that you listed, what is the standard for the record for the back and forth? Can we simply write spoke in favor or spoke against, or do we have to write enough to recreate the essence of the discussion?
I think that if the discussion's on a site plan and there was a general description of the fact that this is a site plan to build a small strip mall on Route 3A in the town of Bow, and the general characteristics of the proposal as set forth in the plans, that's sufficient. And you can have the recording of people from the audience who spoke saying I support or oppose. You can get into more detail if you want to, but it's not required. However, what I would say is, if your municipality has the resources to pay someone to produce a really detailed summary of what everyone says with their name, with their address, that is invaluable as an attorney representing a town in the Superior Court, or now it's the Housing Appeals Board. If you have a detailed near transcript, I'm not saying you have to do a transcript that really captures all those details of what someone would say with that person's address, that makes your job trying to show that the decision by the planning board was not illegal or unreasonable, but there was adequate evidence in the record to support the board's decision so much easier. Now, that can be expensive. I represented one community where some of the planning board minutes went on for 40 or 50 pages. Now, and those minutes were not produced right away. They took a while to be produced. But if I'm defending a town, if I have a detailed set of very clearly laid out explications of what different people said at a hearing, it's invaluable, but it's not required. Okay, you're only required to have the minimum that I said is necessary for public meeting minutes.
Okay. If you do not receive your documentation required, I guess as a planning board member, what is the protocol at the meeting if you get important information at the start of the meeting? how do you address the applicant? So I guess that would be if the applicant comes to the meeting with information and presents it to you at the meeting. How should they handle that?
Well, I think the way you handle that, and this is, I think, the practice of many of the municipalities that I represented in southern New Hampshire, they had a rule of procedure where the applicants were required to deliver reports, documents, materials, and submission to the planning board the Thursday before the following Wednesday meeting. And if you didn't get it to the planning board that Thursday before the following Wednesday meeting, you were not going to be able to present it, or it would be presented and considered a continued public hearing because you were dilatory and submitted the materials to us so that the planning board could have a decent interval between Thursday and getting the packet on Friday and over the weekend to look at the materials, read it in preparation for the planning board meeting on Wednesday. So I think that's the better approach because, again, having a 10-page civil engineering report dropped in your lap while you're at a planning board meeting on a Wednesday night, you cannot comprehensively, address and absorb that information and make sound decisions.
Right.
And so what you would probably say to someone, okay, we'll take this report, but that's going to force us to continue this public hearing, and that's your fault not giving the material to us in a timely fashion. Now, sometimes it happens. The person just there was a last minute breaking piece of information they didn't know about, and now they have to submit it. And there are always exceptions to the rule, but the better practice to make sure this material is delivered beforehand so board has a decent interval as members to consider the information, not just at the meeting.
Right. Yeah. And it's perfectly fine for the board to say, we're going to continue. The boards should be able to have that confidence that they can't expect to be reading engineering plans and things right in front of the applicant. So, great point. For a site visit, does that mean when it happens, there has to be public notice for it?
There has to be public notice beforehand.
Yeah.
So
Okay.
you have to provide that 24-hour notice, but I think the practice we have, I know that our staff posts the notice of the site visit almost immediately after the application is filed, because we always had to have a standard way of doing site visits. It's either the Saturday before or the night of the meeting. And I know that's posted at Town Hall, it's posted on the website, and then we send out reminder cards, little yellow cards that remind me when the site visit is. And that's the same information was sent to abutters and other people entitled to notice.
Is there one final question on the minutes so we can move on to the next section here? Is there documentation detailing meeting minute requirements? Is there I guess the question maybe, is there like
You've
an
got
outline?
my slide here.
Yeah, that's true.
Okay. So, right here, that's it.
Perfect.
You don't need anything more than this. And this is right from the statute. It's RSA 91-A, :2, Roman 2. So that's where it comes from. And it's
Perfect.
literally a sentence and a half long, or 2 sentences. Okay, so let me move on to the next section.
Thank you.
Conflicts of interest and disqualification. This is the key statute if you're a member of a land use board, and there's 2 elements of this statute that bear attention by a member of the planning board. You are considered a quasi-judicial officer because, like a judge, that's why we use quasi, like a judge, you hear evidence from opposing sides, typically applicants and abutters. You consider the evidence based on certain standards that you're supposed to employ, both issued by the superior courts and the Supreme Court, and also standards in your regulations, in your zoning ordinance, and you make decisions. It's similar to what a judge would do in making a decision on a civil case. So for a quasi-judicial officer or a land use board, you have to avoid direct personal or pecuniary interest. So you clearly cannot be a participating in a case where your employer is the applicant, because that has a direct impact on your pecuniary interest. Nor could you sit on a case where you have a personal interest because you're an abutter to the application or the subject property, or the person who's making the application is someone you're related to by blood or marriage. So clearly that's an easy understood element of avoiding complying with your duties to remain impartial. But you also could be disqualified if you would be disqualified to act in a particular case, as would a juror would be required to recuse themselves from not hearing a case in a civil action. So the standards that we use, the juror standard, this is the ways in which we evaluate whether someone could be an impartial juror in the Superior Court. And it's the same standards that apply to a land use board member. Do you expect to gain or lose in this case? Are you related to either party? Have you advised or assisted either party? Are you employed, or have you directly or indirectly given your opinion? This is an important one. You really can't prejudge cases. Are you employed by any party in the case? Are you prejudiced? Do you employ any of the attorneys in the case? So if the lawyer who represents the applicant is your personal lawyer, you're probably going to have to recuse yourself. So these are the things that we consider when you address the standards that must be followed by a land use board member. Prejudgment is probably the most common issue that can arise for a land use board member or a member of the planning board. So Winslow versus Holderness is the way we take into account that case that came down in 1984. The Supreme Court made clear if a member is disqualified because they have prejudged the case, not only is their vote thrown out, but their participation in the decision-making process, even if their vote was not the determining factor, results in the entire decision being thrown out, and the board has to have the case sent back to them for a new decision. And so Winslow versus Holderness was a situation where a person in a private capacity had clearly voiced a strong opposition to a project that was coming to the planning board. It was well known it was coming to the planning board. And then that person was appointed to the planning board and did everything they could to make sure that the planning board defeated that particular application. And it may have been supporting the application. I can't remember which, but either case, their prior stated opposition to the project or support was one which indicated they had prejudged. And then they went ahead and participated in the case. And even though their vote did not determine the outcome, the Supreme Court said just by the mere participation had the impact of causing the board's decision to be void. And that's because we don't know how that member's participation had an impact on the decision-making decisions by the planning board of that instance. And that required the matter be considered a void decision, and the planning board had to start all over again. Another case, which I think is an important one to take into account to help understand the dimensions of the necessity to maintain impartiality, is Webster versus Candia. A couple of things out of this case which I think are important. Number one, planning board member is not disqualified because his spouse was a leading opponent of the project. We don't have an obligation to be disqualified simply because someone you know or are related to has an opinion which is strongly stated on a particular application. The other part about this case, which I think is important, there was a claim of alleged bias by the one member of the planning board because after the whole public hearing process had been completed, that member went home and sat down and composed a statement, I guess you would say, but it was really meant to be kind of his own thoughts on the reasons why that application should be denied. And so the applicant eventually tried to argue that was prejudgment. But the Supreme Court said, no, that was the member making sound judgments, and it was evidence of their effort to be thorough in terms of their decision-making, and it was the proper exercise of judgment at the appropriate time, so it wasn't evidence of bias. Clearly, if they had composed this before they had heard the evidence, that's a different story. But this was composed after all the evidence had been heard. The member went home, really thought about it, and came back to the planning board meeting at the time they were going to make a decision with those thoughts composed that he used in help rendering a decision on the particular application. So again, that's a good way to compare and contrast what's happened in Winslow versus Holderness versus this case, Webster versus Candia. Another case I think that is important to keep in mind, not for necessarily what it decided, but what it does it augurs something that one has to be concerned with and careful about. Actually, this case and the following case related to the same kind of issue. This was a case where I see you have a question. I'll just stop. Oh,
Sure,
no.
sorry,
You-
a tad late getting to that one, Steve. It was
Okay.
applicable to your previous slide. Thank you. Should the Croydon School Board Chair have disqualified herself when her husband offered the motion to cut the school budget in half?
So I will not offer an opinion on that. Okay.
Okay.
I will just repeat what the Webster versus Candia case tells us, that your spouse's opinions does not control your duty to recuse yourself. And enough said, because I don't know that it would be my place to give an opinion, certainly about a school board matter. We represent towns and we don't represent school boards. So I will decline to opine on that.
Fantastic. Good answer. Thank you, Steve.
Whoops, sorry. So the Robert Foley versus Trustee versus Zenfone case is important because what happened is that while the ZBA was still in the decision-making mode, and before they made a decision, I think the decision that was pending was a motion for a hearing, the chair of the ZBA sent an inquiry about, should precedents be considered binding on a board, prior decisions the board had made when making a decision on a particular case. And he was trying to get input from PlanLink. We all know PlanLink and participate in PlanLink and sharing information. And the ZBA chair received replies and took into account perhaps that information. And then the following, I think, week it was, the ZBA denied the rehearing, and the applicant eventually was able to find out about this exchange of information on PlanLink. And without getting into the great details of the case, the Supreme Court ultimately didn't feel there was an adequate foundation laid and presented at the Superior Court level that the ZBA chair had not participated in the decision-making process in a way free from outside influences, such as the information he may have received from the PlanLink postings. So the court did not overturn the decision simply because the ZBA chair sent this inquiry during the time the case was still pending before the ZBA. But it's a warning to a degree to be on guard about avoiding trying to do things or collecting information. I think this is what I would say the case is about, outside the hearing room, because, I think the hearing decision process by a planning board should take place based upon what the board receives at the public hearing process and in the documents that are received and the testimony. And this, trying to get information through PlanLink may not have been an appropriate thing to be done. It didn't cause this case to be overturned by the Supreme Court, but it's kind of, an inkling that I think the court is suggesting, this type of gathering information outside the hearing room process could be concerning. And related to this case, I think it's more pointedly on this issue of posting messages on social media is the Z1 Express versus Manchester case. So this is a situation where the planning board of Manchester was considering an application for a conditional use permit that would, in the future, allow the construction of a gas station in a more residential zone, and everyone in the neighborhood was opposed to the gas station. The board had held its final evidentiary hearing, and then the board was going to hold another hearing to make a final decision. And before they held the hearing to make the final decision, two members of the planning board, because this was a CUP, a conditional use permit vested in the planning board, posted notices on a website created by opposing abutters, stating that they're going to vote against the project. So that social media posting became known to the applicant's attorney, and when the hearing was convened, the two members were asked to recuse themselves because they had voiced opinions, and they had made prejudgments before a final decision was made by the planning board. And one of the members in particular, he was an alderman, was asked to recuse himself, and he refused. He went ahead and voted against the project, and the project got appealed. And the Superior Court judge said, the member's failure to enter into and participate in deliberation with an open mind threatened the integrity of the deliberative process. And the court relied upon Winslow versus Holderness and vacated the board's decision and sent it back to the planning board. So, word to the wise, don't go on social media. Don't go on social media. Don't go on social media. Because if it's especially a contentious project and you post messages supporting or opposing a project, that's going to impair your impartiality and probably force your fellow planning board members to do it all over again, which is unfair to them and it's unfair to the process. So word of the wise, I think, is generally when there's a contentious project in your community and there's a Facebook page created or social media on a particular application, just stay away from it as much as possible.
Two follow-ups with that, Steve. Thank you. Requesting info outside the public hearing. Oh, hang on. Should a board member get permission from a board at a public hearing first?
Well, I guess I would say this. I don't know that a planning board member is really supposed to be an independent investigator of facts and circumstances. It's reasonable for a planning board member to have questions about, do we have enough information to grant this CUP for wetlands intrusions, or do we have enough information about the appropriate location of that particular intersection or driveway, as the case may be. I think the better practice, if a board member has concerns and wants additional information, they should voice that at the planning board meeting and ask the applicant through the chair to address that request for information. I just don't think it's a good practice for individual board members to conduct independent investigations, because it's a board activity. The board together is making the decision, not individuals. So if you as an individual have a concern, there's some missing piece of information, voice that concern at a planning board meeting and ask the applicant to supply it, or ask staff if you have it, yes, perhaps ask the chair, would he have or she have permission to investigate the issue and bring back more information to the board. But it really has to be a board directed process.
Follow up, had the members waited until after the final decision, would the decision have stood and would their social media posts have been okay?
Maybe. Still don't think it's a good idea because you don't know what's going to happen. So for instance, land use boards have the inherent capacity to rehear their cases. Like there's no rehearing process with the planning board, but there is case law that says a planning board could, before the appeal period is run out, rehear a case and reconsider their decision. So you have to make a final decision, and then people have an ability to appeal that final decision within 30 days of the date of the decision. So if the board decides on its own, oh, I think we made a mistake, let's reconsider this. You don't know if that's going to occur. So, I mean, obviously, you have voiced an opinion when you voted in support or opposing a project. But at that point, as I often say in presentations on effective meetings, you don't need to gloat over whether the case has been approved or disapproved. You're just a member of a body making a decision, and you don't have to then voice your support or opposition for what took place. I wouldn't do it. So stay off social media, please.
Great advice. Thank you.
Yeah. So what do you do if you have a conflict? You got a couple of choices. You can recuse yourself, especially if your board has adequate alternates to step in for you. You can make a disclosure, and that disclosure can come as part of an advisory vote. So there's this statute 673-14, where any member who is not really sure that they have a conflict of interest and need to recuse themselves, they can ask their fellow board members to hear them explain what their situation is and ask your fellow board members to vote whether that you should recuse yourself or not. Now, that voting is something only a member of the planning board can ask for, or another member can say we should vote on whether Steve should vote on this case. But even that vote is not binding on the member who's troubled by their potential need to recuse themselves. So it's an advisory vote. But ultimately, when in doubt, really don't do it. And again, say off social media. So now I'm going to turn to planning board fundamental statutes. And at this stage, I'm about halfway done, Stephanie, and I have to finish by 10:30. So I think maybe for time being now, let's hold questions so I can kind of rumble through. I don't want not rumble to get through some of these key materials, and then I'll let you know when to pick up questions again, and maybe we can hold them to
absolutely.
the end.
I was just doing the same thing, Steve, looking at the clock, and we do have a few questions from, a few slides ago that I said we would get to them at the end. So we have a little bit stacking up, but we're doing pretty good.
Okay, very good.
Thank you.
So the following materials are really designed to give all you planning board members, especially new members, kind of a basic introduction of what I consider to be the planning board, the fundamental statutes, and what are their basic characteristics for you to be aware of and understand. Maybe even read, make available to you. I don't know how many of you have it, but if you don't have it, the Office of Planning and Development every year puts out the New Hampshire Planning and Land Use Regulation Handbook. And your regional planning commission makes these books available to you at a very reasonable price. So if you don't have one, try to get one from your regional planning commission, from town hall, and have them available to you at your side when you are working on planning board matters at a public meeting or elsewhere for that matter. So this is my list. I may not have gotten everything, but this is what I consider to be the fundamental statutes that govern the planning board. The first one, and this is by no mistake, the first statute in RSA Chapter 674 is RSA 674:1, and that defines the duties of the planning board. A good one, if you have some time to go through and understand some of the attributes of the planning board and the duties of the planning board and the things the planning board is expected to do if you want to have a quick introduction to the job of being a member of the planning board. Master planning, clearly a key component of what the planning board does. You have to have a master plan that shows how the town wishes to implement and design its community in the future and manage its land uses. You have to have a master plan before you can have a zoning ordinance, and the master plan is a key component of the planning board's job. Capital improvement planning is something that is either done by the planning board or a CIP committee, which is appointed through a decision by the town meeting. Actually, a capital improvement plan is something that has to be voted. Town meeting has to say, we want a CIP, and then the town meeting can also vote, we're going to have a CIP done by the planning board or by a CIP committee. Zoning ordinances, adoption and amendments, job of the planning board. Subdivision authority and site plan authority, these are specific pieces of authority the town meeting has to give you. So the town meeting has to vote to give the planning board authority to approve subdivisions of land. And that's actually 674:35. 674:36 is where you get subdivision regulations, but you adopt those once you've given the authority. And site plan review, that's the approval of uses of land for non-residential and multifamily uses. The regulations are adopted by the planning board under 674:44. I put the workforce housing statute in here because it is becoming a more important thing that gives us guidance on the expectations of the state as a whole to ensure that housing for people of all income levels are available throughout the state of New Hampshire. Roads and driveway regulation, this is mainly driveway regulation, but has an impact on your roads, 236:13. Merged lots, an element of the planning board's authority, which I'll take a moment to go over for you. Offsite exactions, authority the planning board has to ensure the offsite impacts, especially of non-residential uses, are adequately assessed to someone who has unique impact on those offsite resources, water, sewer, drainage, because of a particular project. And then scenic roads is an element, again, of what the planning board has the authority to manage. So the duties of the planning board, an important statute. It does a number of things, 674:1. It enunciates and makes clear, as to other parts of the statutes, that it's the duty of the planning board to adopt, update, and promote the master plan. The promote part might be something that the planning board would probably do in interaction with other committees in your community, such as Economic Development Committee. One of the other things the planning board is allowed to do and encouraged to do is attend municipal planning conferences like this one put on by the Office of Planning and Development. The statute also authorizes the planning board to enter private property with the consent of the owner to do surveys and to understand and appreciate the impact of a project on that particular piece of property and the surrounding properties. One thing it does say, and this is not uncommon, you'll see this in a number of the zoning and planning statutes where certain things are declared off limits for municipal regulation. One of those off limits that's been declared in 674:1 is the planning board cannot regulate timber harvesting unless it's incident to a subdivision or site plan review. So just a pure timber harvesting activity where someone has issued a notice of intent to cut is something that is not subject to planning board review unless it's connected to a subdivision or a site plan. The master plan, as I've already mentioned, is within the domain of the planning board, the sole domain of the planning board. And in order to have a zoning ordinance, the master plan, at a minimum, must contain a vision provision of the ordinance, what you are the guiding principles, the articulation of the expectations of the citizens in your community on how, what are the priorities for municipal development. You also have to have the land use section. You know, what are the population, economic activity, resources, and that dictate what would be the expectations for your future land uses in your community. So these two elements are the prerequisite to have a master plan that would support the adoption of a zoning ordinance. If you don't have these things, you don't have that master plan, you cannot adopt a zoning ordinance. A couple of things that I would say about master planning. There is no requirement that a master plan be updated or revised in any particular required schedule. In fact, the statute 674:4 Roman 2 says that it is recommended, but not required, that a master plan be revised every 5 to 10 years. But what I would point out is, to the extent your zoning ordinance might rely upon the master plan in defining the need for, say, rare these days, but growth management, or the need to support an impact fee ordinance, if your master plan is out of date in terms of defining what are the capital needs and infrastructure requirements for the community based upon population levels, and you've kind of allowed that kind of data to fall out of date, it may be less likely that your impact fee ordinance will be supported because it's not, it will be legal, I should say, because it's not supported by adequate information in an updated master plan. And there are many other elements that would go into a master plan. I think one of the more common ones you'll certainly see in communities in the Seacoast area is they have to plan for climate change. And I suppose climate change circumstances also dictate changes and impacts that are taking place in inland areas. So I know, for instance, this year, the inland areas of northern Vermont and northern New Hampshire have suffered considerable impacts on their road networks due to a high amount of rainfall and muddy roads and culverts and other pieces of the highway infrastructure not being able to quite handle the current level of rain that has come in the past 6 months. And so we have to be cognizant of issues of that type. So in master planning, whether you have to worry about sea level rise on the seacoast in your seacoast community or your inland community, and you have to deal with other forms of climate change, master planning around those issues would be an important element of the duties of an updated master plan. As I mentioned, the CIP is the fundamental duty, which is in the first instance dedicated to the planning board, although in my community, for instance, we have a CIP committee, which is appointed by the select board. But even if you have a CIP committee, you're still going to have to have at least one planning board member on that CIP committee. And so those of you who are familiar with CIP planning, it's really designed to make sure that we're adequately looking forward in the future to those capital improvements we have to pay for, the new fire truck, the rebuilt town hall, the reconstruction of different roads, all those pieces of capital improvements that are defined typically as a piece of infrastructure that has a useful life of at least 5 years and has a cost of anywhere between $10,000 and $25,000 that we have to plan for in a rational way and make sure that rather than having to suddenly have spikes in the tax rate in any one year, we set aside dollars in capital reserve funds according to a plan for when we have to buy that fire truck or when we have to buy those police cars or any other pieces of municipal infrastructure. And ideally, what it does is it encourages the budget committee, the select board, the governing body to set up capital reserve funds for the purpose of saving for those pieces of capital improvements that will have been projected as necessary, whether it's 5, 10, or 20 years down the road. Ultimately, though, the CIP is only advisory. It's not binding on the select board, the governing body, town council, city council, or the budget committee, or the decision makers who adopt the budget in your community. But it should be quite influential and should have some important way in which it would communicate the needs for the community today, tomorrow, and 5, 10, 20 years down the road. A CIP, though, is not regulatory, so you could not deny an application before you as a subdivision or site plan because it seemed out of whack or it have some inordinate impact on your infrastructure, or perhaps would justify a change in the plans for the CIP. CIP is not a regulatory document. It's merely advisory. It gives advice to the budget writers in your community and budget deciders, but it doesn't bind them to follow the CIP as proposed. Zoning amendments is probably one of the more important elements of the planning board's job. Now, I have up here the basic elements of the zoning amendment statute that governs adopting and amending a zoning ordinance in towns, but I would just point out that although I don't have it here, for cities, the zoning amendment process is found in RSA 675:2. And the decision-making process in most cities, the initiation of a zoning amendment comes from the city council or from the executive, although there might be planning board hearings and input. Ultimately, it's a process driven by the city council. However, in towns, city council or board of aldermen, in towns, it's the planning board that proposes the initial zoning ordinance. The planning board and, by the way, the select board can propose zoning amendments. You have to have in front of the planning board at least one public hearing before any zoning amendment can be proposed to the town meeting. Another one has to have held 14 days later if it's substantively modified after the first public hearing. And then the final proposal, it has to be delivered to the town clerk for consideration at the official ballot voting day when you go into the polling place and vote on zoning amendments the 5th Tuesday before town meeting. And petition amendments are ones where the planning board can state its approval or disapproval. I would just say it is critical. I know that some towns have struggled with this recently. When the planning board finishes the zoning amendment process, I really think the better process is for the planning board to then vote. Madam Chair, I move we put proposed Article 1 on the ballot to modify our regulations for accessory dwelling units. So I think it's a good process after you've completed the zoning amendment hearings to then have a deliberate vote on each proposed zoning amendment. And I have seen it, where the planning board, after the final public hearing, realizes one of the proposed zoning amendments is not ready for prime time, and they vote not to put it on the ballot. And that's perfectly okay. But you would vote deliberately. Yes, you've got 4 amendments, and they're all going to be adopted by, proposed, be presented to the town clerk, and then someone needs to go to the town clerk with the actual wording of the proposed zoning amendment. And ideally, this is the at-length description of the zoning amendment, and then also preferably, and maybe you do this in conjunction with town council, the ballot question. And by the way, the ballot does not have to contain the complete zoning amendment, because sometimes you could have a zoning amendment that would go on for pages. It just has to have, do you support the adoption of zoning amendment number 1 as proposed by the planning board, and then with a brief description of what the amendment is all about. Subdivision and site plan approval, probably the one activity that the planning board is going to spend most of its planning board meetings at, is approving subdivisions and site plans. I'll talk about requiring preliminary review of subdivisions later on in the second section, but you have the power to approve plats because the town meeting has voted under 674-35 to give you the power to approve divisions of land. But that also would include the approval of things that would become public infrastructure, including streets, utilities, and other facilities. In order to have site plan review, you have to have a zoning ordinance. There are some towns in the state that have no zoning ordinance, but they have a planning board that approves subdivisions, but they can't have site plan review because they don't have a zoning ordinance. And in order to not only must you have a zoning ordinance to do site plan review, but the planning board has to adopt regulations, and that they have to be in place, have to have subdivision and site plan regulations in place. And by the way, planning boards also have the power to approve any change or expansion of use of a site plan. But we'll touch on some of the issues that relate to how a town might think about having a regulation that says, we have an approved site plan. When are you going to require someone to get a revised site plan based upon changes to the approved site plan? And are you going to permit site plans that have de minimis minor changes without having to come back for full site plan review? As I mentioned, I did put a slide in here about the workforce housing statute, which I would suggest to you was something that we all have to take seriously more and more as we face the affordable housing problem that we have here in the state of New Hampshire. A couple of duties are imposed on all municipalities under the statute. Workforce housing has to be allowed in the majority of the land area zoned residential. So if your zone, if you have, like in my town, we have the residential zone and the rural agricultural zone, and the rural agricultural zone is the predominant land area in our community, that has to allow workforce housing in that large area, or the majority of the land area zoned residential. And the other part of the statute, which is a little more complicated to flesh out and how you put those details together, but a municipality is obligated to have its fair share of workforce housing. And typically that's done on a county-wide or maybe a series of communities that are either abut the abutting communities, a regional analysis of what's the fair share of workforce housing. And I'm not going to try to go through how one would calculate that, but there is a duty to ensure that all communities have its fair share of housing for people of all income levels. The one part that touches the planning board process with regards to workforce housing, it contemplates in the statute an interactive process between the workforce housing developer and the planning board to come up with conditions that don't make the project unaffordable. But in order for that statute to be implemented, if someone is going to take the benefit of a developer is going to argue, I've got a workforce housing project, they've got to enunciate as part of the application, as the submittal to the planning board, this is a workforce housing project, and these are the reasons why it's a workforce housing project. And ideally, that application could state, and we plan to either rent the units or sell the units, however they're going to be built or proposed, so that they are affordable based upon affordability guidelines, which you can find at New Hampshire Housing Finance Authority. So that's kind of a necessary step. If someone's going to claim that we're protected under the workforce housing statute to certain procedural protections, then they have to say that as part of the application process. And that statute then says, this is how it's supposed to play out. If the planning board approves this affordable housing project, but says, let's as an example, it's not the best one, that's the one I've seen before, that let's say your regulations require that new streets, let's assume there's a new street that's being built, has to have granite curbing, which could be significantly expensive, and the applicant comes back to you and says, I can't afford this granite curbing. It's going to drive up the price of the housing beyond the price point that keeps it affordable. I want you to waive that requirement. The statute contemplates that you're supposed to have an interactive discussion with the applicant to resolve these concerns. And then ultimately, if you don't resolve the concerns, the applicant has this ability to file an appeal with the Superior Court, where the Superior Court can determine what's really considered affordable and whether or not the planning board should have waived that granite curb requirement or other requirements which are deemed to make the project unaffordable. I don't know how often this process has been used, but I just wanted to make you aware. Again, the two things you need to know, that if the person's claiming it's an affordable housing project, they have to do it up front at the time of application. And that there's this need to negotiate perhaps conditions of approval that might have an impact on affordability. Innovative land use control is another important element of what I think is in the toolbox, so to speak, for local land use activities, and certainly it's an important part of what the planning board might be involved with. It's really designed, from my perspective, to allow the planning board to have some zoning authority, which most of the time the ability to get relief into the zoning ordinance is reserved completely to the ZBA, the Zoning Board of Adjustment, where the Zoning Board of Adjustment gives relief by the way of a variance or a special exception. Well, a conditional use permit process allows the planning board to grant that relief. And the most common area that I've seen it's used, I know that we use that in my community, where it used to be the case if you have wetland zoning, and someone wanted to get a special exception to have some activity in or near a wetlands, in a buffer, so to speak, you had to go to the ZBA to get a special exception. This way, you could have the planning board give a conditional use permit to grant relief for some wetlands impact. Now, the reason why that's a beneficial way to approach it, because it's often the planning board that's being asked at subdivision approval to put in a road that's going to impact wetlands. So why not combine the decision on how the road is going to be built in the subdivision process with this other element of the zoning relief to get permission to have an impact to a wetland buffer or a wetland itself? And there's some logic to have it as a one regulatory stop to address both issues. So innovative land use controls are important, and it's in the innovative land use control statute that you would find impact fees and other more sophisticated manners of carrying out land use regulations. Planning board has a big impact on public streets. So as part of your decision-making authority, planning board would approve a new road in a subdivision or a new road in a site plan. The planning board also, more likely than not, in its regulations, is going to have road construction standards, of course. What are the expectations for how wide the road is and how deep the bituminous concrete and how much gravel and subbase and all those elements that go into the proper construction of roads? Those are going to be in your regulations. But ideally, there has to be or should be some harmony between your regulatory standards for building roads for subdivisions and site plans and those that the town would employ for building regular town highways and roads. Planning board also has the power to establish minimum occupancy, minimum completion. So if you have a project that's having a new road that's being built as part of the subdivision approval, at the time of approval, the planning board can stipulate what's the minimum amount of road completeness that will allow homes that are being built or dwelling units that are being built to allow them to be occupied before final completion. Because it is a reality of construction that you may not want the final course of bituminous laid down on a highway while construction trucks are still going in and out of a road. And it's probably not reasonable to command the developer to complete the road completely before they're allowed to sell and occupy homes, because that's not the reality of the cost of the economic cost of carrying out development. So the planning board can say, what is the minimum amount of completeness that a road must attain before homes can be occupied on a new subdivision road. And finally, it's the duty of the planning board to ensure that if you're approving a project and that project is subject to construction of a new road that will be offered to the town in the future as a new public road, you can ensure that it's completed by performance bonding. And typically that's going to come in the form of a letter of credit, although more often today, a project will get a surety bond issued by the insurance company. Those of you who remember 1991, when the 5 biggest banks in New Hampshire went belly up, all those letters of credit that the towns held as security for construction of public roads vaporized in an instant when those banks were taken over by the FDIC. So probably in the long run, I think you'll typically get better security for performance bonding through an insurance company. Maine Bonding, Liberty Mutual, they're all involved in ensuring these projects through performance bonds and surety bonds. And I think that's perhaps a more appropriate way, although letters of credit still exist as a mechanism to ensure completeness. I don't think we're going to experience again the 5 biggest banks in New Hampshire going belly up in 1 year, but caution may dictate that you have more likely security with a surety bond. So that's part of the planning board's duty to make sure these things are put in place to ensure completion of roads that you've required as part of the approval of a subdivision or a site plan for that matter. One other thing I have put in here, just as a piece of a side note, the planning board does not have jurisdiction to make a decision as to whether or not an adjacent town road or public road has a certain status. It's just not something that falls within the jurisdiction of the planning board. I'm just going to move through a couple of these slides pretty quickly now as I'm getting close to turning into a pumpkin because I'm almost at 10:30. Planning board or the governing body has the authority to have driveway permits, issue driveway permits, and have driveway regulations. So it's an important element of why we require driveway permits is to ensure that the private connection to the public road is built in a fashion that doesn't undermine the adjacent public road or cause sand, silt, or water to cast onto the adjacent public road, undermining the road or putting out water that turns into an ice slick and that creates hazards for the traveling public. Planning board also has the power, and in many communities, this is probably delegated administratively to staff to approve merged lots. You don't have to have a public hearing to approve the merger of adjoining lots, which is a common practice that people want to combine lots together, and they have to be under common ownership, and they have to be abutting. I don't think you can merge a lot that is separated by a public street. They have to be abutting each other. One thing I want to mention, just to be sure you understand, that if someone is proposing to merge 2 lots together, they are abutting each other and they own both of those lots. You need to make a particularized inquiry. Are either of these lots subject to a mortgage? Get them to make that representation to you, because if they are, the mortgagee, the lender, has to consent to the merger of the lots, and that consent will have to be part of the approval document by the planning board or the planning board staff that's recorded at the Registry of Deeds. Planning board has the power, which is an important one, to impose offsite exactions on projects that you approve. You don't have to have an impact fee ordinance, but you do have the authority under 674-21 Roman 5J to say this project, whether it's a subdivision or a site plan, is going to have a uniquely untoward or difficult an impact on an adjacent piece of public infrastructure that the developer has an obligation to pay its fair share for improvement of that infrastructure. Now, requiring someone to make an offsite improvement, that's an improvement off the site of the development, more often site plans, that's limited to highway, drainage, and sewer and water upgrades. So if you think the new Walmart has to have an XL or a decel lane or a traffic light to manage the traffic going in and out of the new Walmart, this is the authority you would turn to impose that requirement as part of the site plan approval for that particular Walmart. Planning board also has the authority to manage the approval for the removal of trees on a scenic road. So those of you who are familiar with the scenic road statute, a road can be designated as scenic, and any work done in the road, this is not on the abutter's property, but in the road, within the road right-of-way, that involves the removal of trees above a certain circumference. So any tree that is 15 inches in diameter, 4 feet above the ground, have to receive the approval of the planning board for removal, or changes or impacts on a stone wall. But that requires, again, the designation of that road as a scenic road, and the planning board has to hold a public hearing, and the planning board has to exercise its discretion as to whether or not to grant or deny this request to remove that tree or to modify that stone wall, consistent with the purposes of the reason why the road was originally designated as scenic. So, Stephanie, I have left, I think, 10 minutes more to perhaps do some of these cleanup questions that we reached at this stage.
Sure, absolutely. Let me get back, and I took my notes and get back a little bit here in the chat. So okay, thank you. So question regarding the public attending, can the public attend site visits of earth excavations, can the public attend annual site visits of earth excavation sites?
So if the planning board is the excavating regulator under 155-E, I think it is, I'm not always remembering my statutes, and you have a process where there's a public, the planning board does a site visit of an excavation, that's a public meeting, and the public has the right to attend, and that could be tricky in an excavation site. So I think it's just a matter of working out the public's ability to be there while the planning board is doing that site visit. That's assuming that the planning board is doing that as a public meeting. But let's assume otherwise. Let's say the planning board says, we're not going to go out to the site visit as a board, but we're going to assign, one member of the planning board to do that, maybe accompanied by a civil engineer. Well, that's not a quorum of the planning board, so it's not a public meeting. But if it is a quorum of the planning board, then it is a public meeting, and the public has a right to attend.
Okay, thank you. Moving on. Okay, what should a town expect from its attorney? I.e., is it to be expected that the attorney scoff at the wording of town ordinances, or tell the board that an applicant is correct and the board is interpreting things incorrectly?
I think the planning board's attorney should give the planning board the advice that the attorney believes is the most correct interpretation of town ordinances and state law on whatever subject the attorney's been asked to give. That the attorney has an obligation to give the advice in a way that zealously represents the interest of the municipality. So that's what the lawyer's duty is under the Code of Professional Responsibility. And I would assume every lawyer would do just that.
Okay, thank you. Just for clarification, can you have site plan review without zoning?
No.
Okay.
Got to have zoning to have site plan review.
Okay. Okay, let's see. For timber harvest, must comply with wetlands. This may be a statement or a question here. Timber harvest must, however, comply with wetlands protection, silt fences, temporary or permanent roadway construction, dust abatement, storage or disposal of chips or brush, correct?
Well, I can't give you chapter and verse, but it is generally true that those who have filed a notice of intent to cut on property in your municipality do have imposed duties set forth in, there's a statute on this, and I can't remember off the top of my head, that they have to carry out best management practices with regards to their cutting activities, minimize impacts or avoid or not carry out impacts on streams, intermittent or otherwise. So there's a whole host of obligations that are imposed, which if they are not complying with the Department of Environmental Services or I think it's the Department of Agriculture, there is a state forester who has some jurisdiction of citing timber harvesting operations that are violating those rules that govern timber harvesting. So they have those duties, and they have to abide by those duties, and they cannot destroy, impair, or cause damage to wetlands and fail to take appropriate remediation measures to prevent harm to either wetlands, ponds, streams, intermittent or otherwise.
Okay, thank you. If a board member feels there is a conflict from another board member, can they call for a vote of recusal?
Well, yes. And I'm going to read the statute so I don't make any mistakes on this. So 673-14 says, when uncertainty arises as to a board member's disqualification, a board member in particular, upon the request of that member or another member. So the member who believes they have a potential disqualifying issue or another member can take steps to vote on whether the member in question should recuse themselves. So it gives any member of the board the ability to say, I think we will vote on Steve's disqualification. Or Steve can say, I'd like to have a vote on my potential disqualification. No member of the public, however, no applicant, no abutter can ask for a vote on Steve's necessity of disqualifying himself.
Okay. I just wanted to back up also just to make sure we answered this gentleman's question. Requesting info outside public hearing, should the board member get permission from the board at a public hearing first?
Well, I think I tried to emphasize that, if I'm as a member of the board and I'm at a public hearing and I hear that there's a deficiency on information on a particular aspect of the application, I should make that known at the public hearing, and I could either ask the applicant to come back with the information, ask the board chair to ask staff to get the information, or tell the board chair, I'm going to look into this without objection, I hope, from my fellow board members and come back with additional information. So you're sharing this endeavor to gather the information, but I think it should be, you should first ask staff to get the information. Well, first ask the applicant the information you think is deficient, then ask staff, and then, if you don't have those resources, tell the board chair, would you object if I look this up, and bring the information back at the next meeting. I think that would be the better practice.
Okay, thank you. What is the minimum you need to have zoning? Can the whole town be one zone with all uses permitted in that one zone?
Well, I think the best example of that is the statute that allows you to adopt emergency temporary zoning. So in emergency temporary zoning, that's exactly what you get. So there is and the town of Dalton did this recently. There is a mechanism in the statutes where rather than crafting a zoning ordinance, you just adopt what's called emergency temporary zoning. And the emergency temporary zoning ordinance, in fact, is, and this is found in RSA 674-24, does exactly that. It creates, did I just forward that on you?
Oh, you're
Sorry.
Okay.
Okay. It creates a zone, a town which has one zone, rural residential, and then other uses are allowed by special exception. So if that's an emergency temporary zoning, yes, you could, and there are towns that have adopted that as their permanent zoning. You could do that.
Okay. We have a few people on the phone we want to try and get in before we hit our break. So if Katie could help us out with that and get some people that have been patiently waiting on the phone.
Yes, absolutely. So first
Thank
we
you.
have Margot, who's been raising her hand. So Margot, I'm going to allow you to unmute yourself and you may ask your question. Margot, if you're still there,
Yeah.
there you go. Perfect.
Sorry, I'm actually on my computer. My question is, can the planning board get involved with the height of new Eversource poles in our town?
I would suspect that the height of poles that are reused either within the right of way or in utility corridors is probably governed by the Public Utilities Commission and or the Federal Energy Regulatory Commission. Typically, if we're talking about utility poles within the town's right of way, those have to be located after the pole has been given a license by the select board. Whether or not the select board, as part of that licensing process, and this would be in RSA 231, don't know the exact subsection off the top of my head, could include limitations on the height of those utility poles. I would say perhaps, and I think you'd probably have to seek out specific guidance on that from town attorney. Could the select board manage pole height through the pole licensing process? But I think it would be different for the height of poles that are used within utility corridors. That might be predominantly or only regulated by the Federal Energy Regulatory Commission and or the Public Utilities Commission.
Okay, thank you.
Thank you.
And so we'll move to another caller and we can get a few more in here before we take our break.
Yes, I see two more, so we'll just stick to the two, and then anybody else, we'll address in a minute how we will answer any unanswered questions. So the next person is Nelson Disco. I will allow you to unmute yourself. Up in the top right-hand corner, you may ask your question.
Am I unmuted now?
You are, yes.
Okay, thank you. Steve, I'd like, first of all, good talk and lots of good issues, but I wanted to ask for a little clarification on what you said about off-site exactions associated with a site development, where you mentioned that you could only get exactions regarding drainage and something else. And I wondered if you'd clarify that for me, please, if we can get other exactions besides drainage for an off-site impact.
Okay, Nelson, and thank you. Thank you for the question. Probably one of the most experienced planning board members in the state of New Hampshire, Nelson Disco from the town of Merrimack. So the limitation that attaches there is it has to be offsite exactions have to be related to highway, drainage, and sewer and water utility components. Those are the things that you can require a project to pay for improvements has to be one of those attributes: drainage, highway, water, and sewer utility components.
Okay, it couldn't include sidewalks then, I gather. Well,
okay. Sidewalks are part of the highway.
Yeah.
So I think it's not unreasonable to say that highway design and construction includes sidewalks. So I think it could be argued that because sidewalks are part of the municipal right-of-way infrastructure, a sidewalk could be included within what you could require offsite improvements for. But you got to make sure the necessity for it is driven by this particular project. And that could be a little bit trickier with a sidewalk, whereas it's a lot easier to say, yes, we have to have this XL or decel lane for this particular project. So it really does demand that the particular need for this project is driven by this project alone, not just that the community wants to have a sidewalk here, but that the need for the sidewalk and the people who use the sidewalk